Welcome back to Organized, the business law breakdown. I'm your host, Professor Seth C. Orenberg, and today we're diving deeper into the fascinating world of money damages in contract law. If you've ever wondered what happens when you win or lose a contract lawsuit, stay tuned. In the last episode, we revealed how the expectation interest drives contract damages. Put simply, contract remedies try to put an aggrieved party in the position it would have been in had the contract been performed. But measuring this expectation interest requires predicting how things would have been if they all went according to plan, and they obviously didn't. This kind of prognostication is not always possible. So today we're shifting gears to look at what happens when expectation damages are inadequate or inappropriate. By the end of this episode, you'll understand the ins and outs of alternative money damages, including reliance damages, punitive damages, nominal damages, and liquidated damages. And in the next episode, we'll get into the exceptional, equitable remedies, including specific performance and negative injunction. Before we dig into today's details, here are 3 key takeaways you'll gain from listening to today's episode. You'll learn what are reliance damages and when they're appropriate as a substitute for expectation damages. You'll understand when nominal damages of a symbolic amount, like $1, might be awarded in contract cases, and why courts don't punish people for breaking contractual promises. Finally, you'll discover how parties can agree in advance to a measure of damages called liquidated damages, and what are the limits to this common practice. So, if you've ever been curious about what happens when standard contract damages don't fit the bill, stay tuned. We're about to unravel the complex world of alternative remedies in contract law. Let's start by breaking down some key concepts in alternative money damages. While expectation damages are the primary preferred remedy in contract law, there are situations where they may be inadequate or inappropriate. In these cases, courts turn to alternative money damages or equitable remedies. Reliance damages are one such alternative money damage. Reliance damages are expenses incurred by a party in preparation or performance of a contract before the other party breached. And the purpose of awarding damages based on this reliance interest is to put the injured party back into the position they would have been in had the contract never been made. Punitive damages, while rare in contracts cases, are sometimes awarded when a breach is also a crime or a tort or some violation of other law or statute. These damages go beyond compensation and are meant to punish the breaching party and deter serious wrongful conduct in the future. Just a breach of contract is not the kind of wrongdoing that we aim to breach. In fact, we'll learn today that breach can be efficient, can be socially beneficial. So we don't punish it, we simply require in general the payment of expectation damages. Nominal damages are a small sum awarded when a breach has occurred but no actual loss can be proven. They are a symbolic victory for the plaintiff, such as the award of $1 or $100. Finally, liquidated damages are an amount the parties can agree to in their contract as the measure of damages in the case of a breach. These are useful when damages might be difficult to calculate, but they must be reasonable to be enforceable. It's crucial to understand that these alternative damages serve different purposes, or they fulfill different interests. Expectation damages protect a party's interest or expectation in receiving the benefit of the bargain. Expectation damages are forward-looking. They have to deal with how things would have turned out had the contract been performed. Reliance damages compensate a party for losses incurred by relying on a contract that was subsequently breached. Reliance damages, based on the reliance interest, are backwards-looking, and they look to unravel or untangle the actions taken in reliance that wouldn't have been taken but for the contracting. Punitive damages deter egregious conduct. They're only available where there has been some other harm other than contract breach, because by definition, contract breach itself is not egregious. Parties can breach their contract so long as they're willing to pay the expectation interest, the benefit of the bargain. In fact, parties do this all the time and sometimes for good, socially beneficial reasons. Courts consider several factors when deciding what type of damages to award. They'll look at the nature of the breach, the difficulty of proving actual or expectation damages, the conduct of the breaching party and the wrongfulness of that conduct, and the agreement of the parties, especially in the case of liquidated damages. Understanding these concepts is crucial for anyone involved in contracting, whether in disputes where it may be obvious because these are the results of lawsuits, but even in negotiations. Because how courts approach the end result of a contract in court should shape how we go about negotiating them in the first place. Let's break it down with a case that illustrates how alternative money damages may be necessary. Here's what happened in the case of Baskin Robbins versus Copeland. Baskin Robbins was planning to close one of its ice cream manufacturing plants in Vernon, California. Kevin Copeland, an entrepreneur, expressed interest in buying the plant, but there was a catch. Copeland's purchase was contingent on Baskin Robbins entering into a separate agreement to buy ice cream from him for the next 3 years. This so-called co-packing agreement was critical to making the deal financially work for him. The parties went back and forth, trying to hammer out terms for months. Baskin Robbins even sent Copeland a letter summarizing the basic deal. They sent him a term sheet. Copeland would buy the plant, and Baskin Robbins would commit to buying millions of gallons of ice cream under the co-packing arrangement. Copeland signed off on the term sheet, and he paid a $3,000 deposit on the transaction to purchase the plant. But before the deal was finalized, and before Copeland bought the ice cream plant, Baskin Robbins pulled the plug. They returned Copeland's deposit and said the co-packing agreement no longer aligned with their business strategy. At this point, he sued, claiming Baskin Robbins had breached a contract to negotiate the co-packing deal. He effectively argued that this term sheet, which wasn't a final deal, was a type of contract that required Baskin Robbins to get to a co-packing deal in the end. So this is a pretty interesting case, and the California Court of Appeals ruled on 3 points of law that have significant implications for contract law. First, we have this term sheet. What is a term sheet? It's sort of an agreement to agree. It's not the agreement itself because it's not a contract, and we know that it's not the final terms. But why do parties sign it? Because they want to have some reliance on the fact that the parties are going to negotiate in good faith toward a final agreement. The court said that this term sheet was a contract to negotiate, and that can be enforceable. Term sheets actually can be enforceable, even though in other lessons we've talked about how people think they're not. But actually, term sheets can require an agreement to agree. Parties are agreeing to negotiate toward a deal in good faith. So the agreement does create some binding obligations. It doesn't create the binding obligations of arriving at the final deal. The failure to reach a final deal is not a breach of a term sheet. It's not the final deal, so you don't have to end up there. What was a potential breach here is if one party walks away in bad faith or otherwise stops the negotiation process, because once you have a term sheet, you may have an obligation to carry out the negotiations in good faith. Second, the court addressed remedies for this breach. It found that there was a breach because there was a walking away from the agreement to agree. What are the damages? Well, Copeland wanted expectation damages, but the court ruled that expectation damages are inappropriate because they can't be calculated with reasonable certainty. Remember that expectation damages are about giving an injured party the benefit of the bargain, what they would have gained if the contract had been fulfilled. But when a contract itself is just an agreement to negotiate, what would you have gotten had the negotiation succeeded? That's really unpredictable. We don't know what the final deal would have looked like. If we did, we have the final deal. So since the final deal is unpredictable, it's hard to say what the expectation damage from this interest would be. Instead of expectation damages, which would have been forward-looking and hard to predict, the court awarded reliance damages. which are designed to reimburse the injured party for costs they incurred relying on the promise to negotiate. So how much were reliance damages in this case? The court looked at Copeland's specific claims and found they were zero because Copeland didn't provide any evidence of reliance damages. He had focused his entire lawsuit on lost profits from the co-packing agreement he expected to get. But those are expectation damages. His litigation strategy was totally bankrupt. It was based entirely on the premise that he should receive expectation damages, which are speculative in this case. Since he didn't show any costs he incurred by relying on the negotiation promise, he walked away with bupkis. Since Baskin Robbins returned his deposit check, he didn't have any damages to show for this entire case. It just goes to show you why understanding remedies is so important to all of contract negotiation and litigation. The Copeland case is a great example of how courts carefully navigate the line between enforcing contracts and protecting parties from unfair or speculative liability. It underscores the importance of understanding the type of contract you're dealing with and tailoring your claims and allegations to the appropriate remedies. For businesses, this case highlights the risk of agreements to negotiate. If you're entering into preliminary negotiations, you better be sure about your obligations and document any costs you incur in reliance on negotiating the deal. If Copeland had incurred costs in negotiating the deal and had been able to prove them, he would have had some recovery. And for its part, Baskin Robbins' lawyers should have known that by signing this term sheet, they had an obligation to negotiate in good faith. For legal practitioners, Copeland is a reminder to align your damages claim with the type of breach at issue, and don't put all your eggs in the expectation interest basket. The key takeaway from Copeland versus Baskin Robbins is powerful and simple. A contract to negotiate is enforceable, but it comes with its own rules and limits. Expectation damages might be the norm in most contract cases, but here, reliance damages are king. Let's explore some what-if hypothetical scenarios that illustrate the principle of alternative money damages. Imagine that Tina, the trapeze artist, enters into a contract with the Flying Squirrels Circus. According to their contract, Tina agrees to perform at the circus's main event for the upcoming season. In return, the circus agrees to pay Tina a percentage of ticket sales. In reliance on the contract, Tina incurs significant expenses. She hires a personal trainer, she buys custom-made costumes, and even rents a local gym in which she can practice her routines. Tina's expenses are made in anticipation of the percentage fee she expects to earn from the contract. However, just a week before the season begins, the circus breaches the contract. We'll just stipulate that as a fact. The circus informs Tina they've canceled the show. So this is an anticipatory repudiation. As a result of the breach, Tina is left with no performance and thus no percentage fee. So how can Tina recover from this breach? Let's consider the different types of claims. Tina might struggle to claim expectation damages because it's difficult to prove with certainty how much ticket sales would have been. What would her percentage of this have been? Tina could likely claim reliance damages for costs she incurred because of the contract, but only expenses that she would not have incurred but for the contract. So looking at each of them, the personal trainer, the costume, the gym rental, the circus would probably counter-argue she would have paid for some of these things anyway, like a trainer to stay in shape for her job, although Tina would argue that she hired them and utilized them exclusively because of anticipation of this contract. So this is actually a factual question at the end of the day. Tina may not be able to prove any actual loss, in which case her award would be only nominal damages. We've already stipulated that there's a breach, but just because there's a breach doesn't mean there's reliance or expectation damages. There is some damage award, and it may be nominal, a small sum, maybe $1, to show her symbolic victory. Punitive damages won't apply unless the circus's conduct was particularly egregious. For example, if the circus had defrauded Tina and never planned to hold an event at all, perhaps that would give rise to additional damages in the tort of fraud. If the contract had included a reasonable pre-agreed amount for damages in case of breach, the liquidated damages clause could be enforced. Unless, as we'll see, it arise at the level of a penalty. So let's talk briefly about liquidated damages and penalties. Again, a liquidated damage is simply the idea that people can write in their contracts how much damages they should pay or receive in the event of a breach. And these are going to be enforced like most contract terms unless they're unreasonable, unless they're way out of line with the party's expectations in the time that they made the contract. So if a party like Tina had written that if Flying Squirrel Circus cancels its show, it will pay her $1 million, and the maximum expected ticket sales would be $10,000, the court might see that as a penalty and not enforce it because it's unreasonable. This simple scenario demonstrates how different types of alternative damages might apply in a real-world situation. It highlights the importance of being able to prove damages and shows why reliance damages can be a crucial alternative when expectation damages are difficult to establish with reasonable certainty. Moving to pop culture, the hit TV show Shark Tank offers an excellent illustration of alternative money damages in contract law, particularly in the context of business negotiations and deals. In Shark Tank, entrepreneurs pitch business ideas to a panel of sharks who are successful business people that may invest in the idea. Often we see the sharks and entrepreneurs engage in intense negotiations and reach tentative agreements on the air. Imagine a scenario where a shark and an entrepreneur shake hands on a deal during the show, agreeing to negotiate the final terms later. During the show, you see the shark promise to invest $100,000 for a 20% stake in the company. What promise has actually occurred here? Now, I'm a venture capital lawyer myself, and I can tell you that the investment of $100,000 for a 20% stake suggests that we're going to generate a significant volume of documents for this equity finance transaction. It would probably take over a month to transact fully on various types of paper, and we would need a number of terms to be ironed out before this can be finalized. So we don't necessarily hold the sharks to invest the $100,000, but what we do hold them to is to negotiate toward this result in good faith. And this means that the entrepreneur now has access to reliance damages if the shark doesn't perform. So the entrepreneur could have expenses like hiring a lawyer like me to prepare the deal, to scale up production in anticipation of having this investment, and to turn down other investment opportunities, known as opportunity costs. So if the shark backs out of the deal without an attempt to negotiate and without good reason, the entrepreneur might have a case for breach of contract to negotiate. They probably can't claim expectation damages because the future expectation interest is too speculative. What are the profits that would have been made on that 80% for that $100,000 investment? That's just too speculative. Instead, the entrepreneur will probably be better off seeking reliance damages to recover costs incurred based on the shark's promise to negotiate in good faith. This whimsical example from Shark Tank demonstrates how complex business negotiations, especially in the fast-moving world of startups and venture finance, can intersect with fundamental contract law principles like alternative money damages. And it shows when unique opportunities or groundbreaking ideas are at stake, traditional expectation damages may not be appropriate or calculable as a remedy. Let's recap the main points we've covered in today's episode on alternative money damages. While expectation damages are the primary remedy in contract law, there are situations where expectation damages are inadequate or inappropriate, particularly where they can't be calculated with reasonable certainty. Reliance damages compensate a party for expenses incurred in preparation for or performance of a contract before the other party breached. They aim to put the injured party back in a position they would have been in had the contract never been made, the but-for case. Punitive damages are rare in contracts cases because they're only awarded where a breach involves egregious conduct that goes beyond mere breach of contract. Nominal damages are a small sum awarded when a breach has occurred, but no loss can be proven. They're sort of symbolic victory for a plaintiff. Liquidated damages are an amount parties agree to in their contract as a measure of damages in the case of breach. They must be reasonable pre-estimates of potential losses, otherwise they are unenforceable penalties. Courts consider factors such as the nature of the breach, the difficulty of proving actual damages, the conduct of the breaching party, and any agreement between the parties when deciding what type of damages to award. The Copeland versus Baskin Robbins case established that contracts to negotiate, term sheets, can be enforceable. The damages are typically limited to reliance rather than the expectation interest. Understanding these concepts is crucial for anyone involved in contract disputes because they shape how courts approach cases where traditional damages may not suffice, and they significantly impact the outcome of legal proceedings and how we draft agreements. Not all contracts are created equal. Agreements to negotiate require a different set of remedies and expectations, and they challenge us to think critically about what justice looks like when a deal falls apart. So here's a question for you. Have you ever been part of a negotiation where one side seemed to walk away unfairly and unreasonably? Have you ever relied on a handshake and words like, "we'll get it done," only to find yourself left in the lurch? How did you handle it? What do you think about reliance damages as a remedy in your case? I'd love to hear your stories and thoughts, so share them with me. You might hear your experience featured in future episodes. And of course, don't forget to subscribe, leave a review, and share this podcast with anyone navigating contracts, law, and business. Your support keeps us going. Next time, we're diving into specific performance and injunction. When money is not enough to fix a broken contract, courts might turn to the exceptional remedies. Stay tuned for answers to the fascinating question of when money isn't enough. Thanks for listening to today's episode of Organize, the Business Law Breakdown. I'm Professor Seth C. Orenberg, and I thank you for tuning in and exploring the intricacies of alternative money damages with me today. I hope you found today's conversation informative and helpful, and remember, until next time, keep your agreements strong and your arguments stronger.